So, Mr. Lynch,
Yes, Your Honor.
come talk to me for a minute.
Yes, and by that, do you mean from this?
Yeah, no, so you insisted that everybody be in court and then Mr. Harris is at his house?
Yes, Judge. My understanding that this was continued to pretrial, and
Where did you get that understanding?
that's what I thought happened at the last motion calendar, Judge. Mr. Harris is in Colorado. Um, you know, I wanted to be able to confront the witnesses in person in court. My preference was to have him present pretrial.
Okay, that might have been your preference, but that's not the discussion that we had. Does anybody else remember pretrial? Because I do not.
No, Your Honor. Typically, what I've noticed from the court is that if it's pretrial, it's because there is a request for a continued statement requested a dismissal or a motion to deny.
But
But it's not typical for the court to have it pretrial unless it's one stated in the rule nasi, or is if we requested to have that motion dismissed and then you put it pretrial. But I don't recall that taking place because that would have put his other case where Attorney Ward was on pretrial, and that was not the discussion to my understanding.
Yeah,
so,
I don't recall us saying that this case was gonna be pretrial.
well,
So what's the issue?
well, Judge, my recollection to pretrial, Mr. Harris is here present. You know, we are prepared to go forward. Um, that I know that I did indicate that I wanted the officer to be present, and that's why my understanding was that it was going to be moved to pretrial. But you know,
And I was
we're we are willing to go forward. We're certainly ready to go forward, Mr. President. I mean, Mr. Harris um, is present via Zoom. My wanting to have
Well, the gentleman in question, the witness in question, is my understanding, was coming off of a medical leave
right,
due
and the
to an on-the-job injury. So I thought we were trying to accommodate that, but you insisted that he be present, and the state got him present. So
and he
what's
is,
the issue?
and I'm not asking. I mean, I did ask that it be moved to pretrial, but Your Honor denied that, and we are prepared to go forward. And
Okay,
I mean, my preference, the reason I wanted it to be done pre-trial is because I wanted to be able to question the officer from the witness stand with Your Honor present in the courtroom, be able to view that, you know, in this situation, it's easier for me to do this on Zoom, so I'm not standing next to the officer while questioning him, Judge, but I'm not jumping up and down about that and making objections, Judge. I'm ready to go forward in this situation, but
And I would just like to add to that point. I did have an opportunity to ask Ms. Arnold to look at the notes that was placed on the calendar last time it was on the court. This case was scheduled. There was no date set, is my understanding, but it was continued so that witnesses could be present. And so essentially that's what took place.
yeah, because my
When it's
understanding
pretrial,
may I just make a point, Judge?
I'm
wait,
sorry,
my,
Ms.
my understanding was this officer was out on an extended medical leave. And so you insisted that he be present, and I said, fine, we'll continue it until the officer can be present.
Yes,
They've made the officer present.
yes, and Mr. Harris is present via Zoom, and he can waive his presence to this hearing.
That's
Uh,
not fair.
Mr.
You request, Your Honor, the defense requested for witnesses to be in person,
Yes, Mr. Harris.
for Mr. Harris to be on his house while an officer is in court. The attorney is in court. The state is even in court because it's Mr. Tipton's motion. He is even in court. Everybody is in court in person except Mr. Harris. And they've requested us to have witnesses present in person.
Yes, and that is our right to request witnesses to be present in person. And Mr. Harris can waive his presence at this hearing. He is not a witness that's going to testify at this hearing. It's also unfair for Ms. Ponder and Ms. Mr. Tipton to double team me in this manner about this issue. I am having to, but here, I'm here ready to go forward on the motion. The officer is present. I'm not sure what the issue is. Mr. Harris can
All
wait.
right, so, okay, I've heard enough, we're going forward. So this is the state of Georgia versus Donnie Harris. Mr. Harris has two cases pending, but this is the particular case of let's see, case 2022 CR 01475. Mr. Harris is represented by the law firm of Lister, Holton, Dennis. Mr. Lynch, Owen Lynch is present and representing Mr. Harris. Mr. Harris is not present in court, but he is present by Zoom, present by video. My understanding is from Mr. Lynch that he is not likely to testify in this matter.
Sector 4 watch office.
All right, whoever is speaking needs to mute. Mr. Harris is charged with DUI less safe, driving under the influence, count 2, and traffic violation count 3. All right, and we're ready to go forward on the motion to suppress.
We are, Judge. Before we go forward, I just wanted to mention to the court that we do have a stipulation in this case that the Officer Stigger's body cam video is admissible for the purposes of this hearing, to state.
That's fine. Body cam will be admitted into the record for this hearing, as stipulated.
Thank you, Your Honor.
Any recross?
Just briefly. You had never spoken to Mr. Harris before this incident, haven't you?
Not that I know of,
So you don't know how he normally speaks, do you?
not necessarily.
He had a mask over his mask, didn't he? I mean, a mask covering his mouth while he was talking to you,
Yeah,
did he not?
He had a cotton mask.
Okay. I believe you just testified that if he would have tested negative for alcohol in his breath, he would have let him drive away, right?
He would have drove away with the citation for running a red light.
Okay, no further questions.
All right, anything else for this witness, Mr. Tipton?
No, Your Honor. State rest at this time.
May this witness be excused.
Yes, Your Honor.
All right, Officer Stiggers, you're free to go at this time. Be safe.
Thank you.
All right, state may call its next witness.
Your Honor, state rest at this time.
All right, defense has witnesses to call in this case.
Your Honor, defense will not be calling witnesses or presenting evidence.
All right, I'll hear argument.
Thank you, Judge. Judge, as you well know, probable cause to arrest exists in Georgia when the objective facts known to the officer establish a probability that the suspect has been engaged in illegal activity. A probability is less than a certainty, but more than a mere suspicion or possibility. So under the totality of circumstances, you have to look at what evidence do you have that he was an impaired driver. One of the chief things the state is going to focus on is the fact that the officer testified that he ran a red light. With reference to that, I would like to call the court's attention to State v. Blanchard. That is a Court of Appeals case, May 18th, 2016. That's 337 Georgia App 130. And I want to, so in this case, the defendant had driven through a red light, and the officer, which was a fatal accident, and the officer had found a number of pills on him. And in the analysis, the court indicates that the fact that a traffic violation occurred by itself does not establish probable cause that someone is under the influence of alcohol. Of course, you have to go to the totality of the circumstances. Additionally, Judge D'Amato v. State, which is in my motion, establishes that the smell of alcohol, even with an admission to consuming alcohol, does not establish probable cause to make an arrest for DUI. But the state is going to I would anticipate that the state is going to argue that those two things together establish probable cause, Your Honor. However, you have the ability to assess the credibility of the witness in this case, and also to make determination if the officer had actually developed probable cause. Now, when he smelled the odor of alcohol, he indicated that he had a suspicion that he was possibly an impaired driver. However, he did not develop that suspicion further into probable cause. There was no additional investigation that took place. He was immediately put into custody. He was immediately,
We're gonna skip over that whole PBT test?
yeah, no, Judge, I'll mention the PBT. So,
Well, I mean, because you can't go to, okay, red light, ran the red light, and then smell of alcohol. Those are not sufficient. And he did nothing else until he read him until he arrested him. If you don't tell me the
can I
case,
get into
tell me the
PBT?
case.
Sure, Judge. So when it comes to the PBT, as you're aware, a refusal to submit to a PBT test is not admissible under Elliott v. State. Additionally, he did.
Well, it might not be admissible, but when you're talking about the totality of the circumstances, somewhere that has to factor in.
So I would disagree, Judge, because it is my client exercising his right not to produce evidence against himself, which the courts have held is not admissible and should not be used against a defendant in a criminal case.
I
So,
get that. But what you're asking for is a determination of whether what the officer perceived was sufficient. He
right.
may not have based his suspicion on the refusal for a PBT, but in the refusal for a PBT, your client then says, no, give me a blood test. And he indicated during the course of their discourse that he had been in law enforcement for 26 years. And so being in law enforcement for 26 years, he knows the implications of saying, oh yeah, well, don't give me this, the less invasive test, which we can do on the side of the road and I can be on my way, give me a blood test.
So, Judge, I understand the point that you're making, but what I would suggest is that the fact that he didn't indicate that, or he didn't agree to take the PBT may have justified the officer in doing further investigation, but it does not itself establish probable cause, and it should not be considered in the totality of the circumstances. He also indicated that he would take a blood test, as you mentioned, Judge. So what you're left with, Judge, is a traffic violation. You know, I would object to the court considering the refusal and using that against Mr. Harris under the totality of the circumstances, because it is not admissible, and Georgia law says that that should not be considered.
That's not what I said, first of all, it might not be admissible, but you cannot escape the fact that certain indicators will factor into what an officer is going to consider. And I don't care what the case law says with respect to what is admissible at court, because you can't be in the officer's mind. But what I will say is you can't make this argument to me without at least mentioning he was offered a PBT, because even if it's not admissible, he was offered it. So that's an indication of further investigation. And when he was offered a PBT, even though he refused it, he then offers himself a blood test. He says, give me a blood test. And so that part, at least, arguably may be considered.
Okay, Judge, and I understand your point. I'm not going to go back and forth with you on that. We concede that he refused to take the PBT test. But the argument still remains, Judge, that
you're missing my point.
No additional evidence of impaired driving.
The PBT, but then he offers a blood test.
Judge, and I understand that, but the offer of the blood test, he agreed to it, but that is not evidence of his impairment. The state has the burden to prove that there was probable cause, not that he was a less safe driver, that he was a less safe driver because of the consumption of alcohol. Without the PBT, there's no that there was the present system beyond the smell of alcohol. There's no open containers indicating that he had consumed alcohol. There are no admissions indicating that he had consumed alcohol on that day. So, Judge, I understand your point about the PBT. However, the argument is still that the standard of probable cause was not met by this investigation. There was a traffic offense observed, according to the officer's testimony. He pulled him over. He said that he smelled the odor of alcohol, but there were no testimony about stations. There were no field sobriety tests to confirm the suspicion that he was under the influence of alcohol. There's no objective scientific testing to establish the presence of alcohol in his system. Judge, there was basically no investigation beyond the point of, I smell alcohol. Okay, you're not going to take the PBT. You're under the arrest. You're under arrest, Judge. So for those reasons, Judge, we're asking that you suppress the blood result in this case, any evidence that was obtained after the arrest, because the arrest was made without probable cause. And that's the argument, Judge.
All right, let me hear from the state.
Yes, Your Honor. So, Your Honor, with regard to the stop of the red light, I'd like to bring the court's attention to Landwehr, Lanwehr v. State. That's 265 Georgia App 359. In that case, running a red light was considered to be probable cause for the stop. Further, Your Honor, any type of traffic violation, even if it's just a single traffic violation, is enough for a stop. I'd bring the court's attention to Friedland, Freedland v. State, 223 Georgia App 326, which stated that a speeding is or any type of traffic violation would be judged for a stop.
I don't think we're questioning the probable cause for the actual stop. We're questioning probable cause for the investigation and arrest for driving under the influence, let's say.
Yes, Your Honor. And state was just getting to that point, Your Honor. The totality of the circumstances under Steinberg v. State, 286 Georgia App 417. The court must in these cases consider that the police officer had a particularized objective basis for suspecting that the person stopped was DUI. In this case, we have slurred speech. We have slurred speech. We have a very dangerous person. He is his eyes are watery. He's acting in a way that I myself consider to be kind of irrational, in that he was his volume was going all over the place. The officer went into detail about the smell, the slur, and the eyes. Now, the defense is honed in on an absence of standardized field sobriety tests. I wanted to bring the court's attention to Kellogg v. State, 288 Georgia App 265. In that case, there were watery eyes. There was an admission and odor of alcohol. That enough at a roadblock was reason for for probable cause to be found without standardized field sobriety tests. Here we don't have the admission of alcohol use, but we have an unsafe act. Further, Your Honor, State v. Young, 334 Georgia App 161 includes that states that the court may consider driving behavior, refusal to take field sobriety tests, or an officer's observations. We don't have standardized field sobriety tests because of safety, exclusively because of safety. The officer was not attempting to circumvent field sobriety. In fact, field sobriety tests. In fact, he was willing to let the defendant go if he would have given a negative breath sample. If we look at Schlanger v. State, 290 Georgia App 407, visible manifestations on their own are sufficient to show probable cause. In our case, we have visible manifestations and an observed less safe act. Further, Your Honor, I do think that it is appropriate for the court to consider the refusal in this case, because it's not a refusal to make a statement. It actually stated that he would just make a different type of statement. Ergo, I don't think that that Elliott would I don't think that Elliott would apply in this case. Our case is sufficiently different in that Elliott was a total refusal to make a statement. This is not a refusal to make a statement, but a decision to take a different test. And for that, Your Honor, the state requests that the court deny the defense's motion and not suppress any of the evidence. Thank you.
All right, so per the totality of the circumstances, the observation, the officer indicated that he initially dealt with Mr. Mr. Harris. He walked away to verify his information. He came back with the citation. As he got closer, he smelled the smell of alcohol on his breath. He said to Mr. Harris, "Hey, I smell alcohol on your breath. When was the last time you had a drink?" Mr. Harris responds with, yesterday. And so he said, yesterday. So he continues to talk to him, and he indicates that he felt like he was slurring his speech a little bit. He noted the glassy eyes, but he said that could have been because he was older. So he did not go straight to he's impaired. He said, I noted he had glassy eyes, but hey, that happens with older people. So that's a consideration of the factors as opposed to just jumping to a conclusion. He then talks to him about, would you, it's raining outside. Would you be willing to take a portable breath test? All the while the officer is talking to Mr. Harris. Mr. Harris has a running commentary. A Filipino girlfriend talk. I was on the line with my Filipino girlfriend, and man, I've been in law enforcement for 26 years. I need just give me a warning. Just give me a warning. Oh my God. Oh my. And he is agitated. Talking about he's been in law enforcement. Just give me a warning. He's practically begging the entire time. The officer's demeanor never changes. He's straightforward. He's even a little bit lighthearted, kind of, like, hey, let's keep going with what we're doing. So he's agitated. He's referring to having had other, he's just like, I can't get another ticket. Give me a warning. Give me a warning. So when the officer says, well, sir, if you're willing to take a portable breath test, then, I can give that to you here on the side of the road. And he says, no, I'm not taking a breath test. Get that. If you're saying it's a refusal subject to Elliott, fine. But what he then says is, no, give me a blood test. He makes the request. So the officer says, 4 more times. Are you sure? Because it's just it's just blown into the little tube. I can give you a PBT. No, I want a blood test. Are you sure you want a blood test? Yes, I want. He verifies it like 4 or 5 times. Then the other officer arrives on the scene. He reports to that other officer. He was like, yeah, I offered him a PBT, but he said he wants a blood test. So he said, we're looking at ran the red light, smell, slurred speech, glassy eyes, which he says could have been attributed to age, but that could factor in there. The agitation, the begging for a warning as opposed to a ticket. I'm in law enforcement, just talking the entire time. And so at this point, the officer says, well, sir, you've asked for a blood test. In order to do that, I have to put you under arrest, take you to the courthouse, take you to the jail. But I'm going to read you implied consent. He reads him the appropriate implied consent, verifies again, asks if if he would take a chemical test, which is blood, and verifies again. And once again, the gentleman says yes. Even if we take out the PBT, the other factors, case law is replete with indicators of the other factors being sufficient for probable cause for further investigation after a traffic stop, especially if the traffic stop wasn't initially for DUI. There may not have been enough probable cause to stop him for being an impaired driver. But he did run through a red light in the middle of a rainstorm. So after he had probable cause to stop him, at that point, his indicators start to tally up. And so at this point, the court believes that the officer had the requisite probable cause to conduct the investigation that he did and to continue the investigation with respect to reading him implied consent um, and uh, and noting that he believed that Mr. Harris was impaired. And so at this point, this court is going to deny the motion to suppress.
Thank you, Your Honor.
You're welcome.
Judge, I believe that concludes Lister and Holt's business today. May we be excused?
You may.